Lord. Just before I start off, one housekeeping point. We mentioned at the beginning of the day making up time lost from the technical glitch at the beginning of the day. I didn't want to assume we could sit late this afternoon without checking first with your lordships, and it would help me to know for when I should have it.
The technical delay was fairly short, so I'm happy to. I would have thought, would 5 minutes suffice?
Yes,
for your purposes? Yes.
Absolutely, that would be fine. Thank you very much. I'm grateful.
Thank you.
So, my lords, we were on page 757 of the. We were on page 755 of the bundle, and I had just addressed you on the speech of Lord Lawburn. Yes. I was explaining how his formulation, his delineation of the test for when a term should be incorporated into a bill of lading was focused on the word govern, which I was submitting to you, created a more physical and tangible link required between the term from the Charter Party and the bill of lading, one of the bill of lading processes that he highlighted. I'm just pausing for a moment of application whilst I've made that point, applying Lord Lawburn's approach to this test to our disputed clauses. We say the payment premium obligations do not govern loading, shipment or carriage, or the terms on which delivery of the cargo was to be made or taken. They only govern the financial settlement or reconciliation for costs of the vessel's additional insurances as between the owners and the charterers. And I'll return to that when I move on to application at the end of having taken you through this case, but that's just the direction of travel. The next speech, as we noted before the break, is of Lord Atkinson, and this is where the only place in the judgment you see the word germane. And one other notable point of even this short speech from Lord Atkinson is in the fifth line of his speech.
I mean, rather than parsing the words of the speeches, we should be reflecting on what the point of the concept is, shouldn't we, and how it's meant to operate.
Agreed.
Why are we transposing certain terms and not others? Not what particular words that Lord Lawburn happens to have used.
Well, my lord, I can see that, and one of the reasons I'm taking you through this judgment is because there's, as you know, been a proliferation of words and ways to phrase this concept since this judgment. You have also, I won't take you to it, but in Lord Gorrell's speech you have the concept of the terms having to deal with the carriage, loading and discharge.
I mean, isn't the thinking that so far as obligations in the Charter are equivalent to kinds of obligations you're going to get for the contract of carriage in the bill of lading, those terms ought to transpose?
Well, in our submission, that would risk being too loose a formulation. There's various words at play. There's germane. To that word, in the later authorities, in the Anfield and the Miramar, was added the prefix directly germane, and I would say that was out of an intention to reinforce the physical, tangible relationship between the charter term and the bill of lading process. In addition to those formulations, you have in other
authorities. We're talking about legal rights, not the physical act, and there's a set of legal rights and obligations that govern the carriage of the goods, and those are going to go across.
Yes, I agree with that.
I would have thought that the insurance, of who's going to pay for the insurance, as that's a condition of entering the Gulf, is an integral part of that set of rights and obligations.
Well, I'll come on to apply what I'm addressing you on to the clauses in due course. It's my submission that the war risk clauses in the Gulf of Aden clause do not make the payment of the insurance monies contingent on transit through the Gulf of Aden. There is another part of the Charter Party that requires the owner to go through the Gulf of Aden, and all that the war risk clauses do, loosely termed, is regulate after the fact of that agreement who has to pay as between owners and charterers, and that agreement about financial responsibility does not govern, does not practically influence the way in which the cargo is loaded, carried or discharged. It's a financial term, which is ancillary to the practical processes of loading, carriage and shipment. And one of the other context to me taking you through these speeches is the proliferation of different phrases to describe the same concept that your lordship is describing, and how that leads to a little bit of confusion in this area and a dilution of the principle and the primary circumscription of the test that Lord Lawburn is setting out.
What do you say the test is? What is the correct phraseology that you invite us to
My
adopt?
submission is that we should go back to govern, which is the word that Lord Lawburn used. He gave the leading speech in this decision of the House of Lords. Lord Atkinson agreed with it. He says, "I concur with the judgment of my noble and Lord friend on the Woolsack." That's Lord Lawburn, the Lord Chancellor. Despite offering a different formulation of the test with the word germane, my submission is that is a dilution of what Lord Lawburn was saying, and having agreed with Lord Lawburn, that is the primary.
He obviously didn't think.
I thought in your written case you were relying on the word germane.
Or directly germane?
Directly germane is the phrase taken up in many of the authorities, but both parties have submitted to you that the proliferation of different words to describe the test, which include directly germane, directly relevant, governs, are an unattractive situation for the law to be in, because they're all slightly different. And in my submission, germane, which is the one that's been taken up in the majority of the authorities for a period at least, does not accurately reflect the degree of proximity between the charter term and the loading, carriage or shipment process.
Well, are you inviting us to change the test that has been applied in this other cases, or?
But our primary position is that nothing in the law in this area needs to change. But
Right.
our alternative position is if some changes need to be made, or if some clarifications need to be made, the only area which we agree with my learned friend's submissions that needs to be the subject of a clarification is to clear away the clutter of the multiple formulations for this incredibly important aspect of the incorporation process. There's a variety of words to describe the same test. It means that none of them are really accurately covering the measure of the test. And particularly the word germane is a slightly old-fashioned word and probably not likely to be one within the normal parlance of certainly parties active in the trade, commercial men and women, and it's probably not even likely to be in common use amongst lawyers. So does germane today still accurately reflect and allow someone to understand what the test governing, what the test controlling the incorporation of terms at this stage is? And we have some sympathy with the idea that perhaps it doesn't, particularly in this case if the application of the phrase directly germane has led to the decisions in the lower courts that the terms we're talking about were incorporated into the bill of lading, and we say they shouldn't be. Once you focus in on the practical link between the term and the process. And I just will highlight that Lord Gorrell, who also agreed with Lord Lawburn's speech, so the third Law Lord to do so, the second Law Lord to do so in the case, you see that agreement at the bottom of 755.
It doesn't fit very well with your opening submission that this is all really just part of the ordinary process of interpretation, where you're looking at the purpose and you seem to be turning it into some kind of rule that where one construes certain words and then applies them.
Well, my lord, the way that the law in this area has developed is that there are codified a series of steps that one takes when considering incorporation as a sort of aid to the process of working out what the ultimate intention of the parties is. This stage of considering whether a term is germane or not, or I would say governs the processes or not, is one of the tools that have been set down over the last 150 years for helping you along that path to deciding whether party intention will be upheld by the incorporation of a particular term. And so we would say it is ultimately in accordance with my opening submission that you're ultimately looking for party intention, but you have to know how to get to party intention, and there are some established guidelines, we would say rules, my learned friend would say guidelines, about how you reach that ultimate decision about whether something is consistent with party intention. And one of those features is regulating how you decide whether a term is consistent with the substance of the processes that a bill of lading is solely concerned with, and not something that is ancillary to those core processes with which the bill of lading is concerned. I won't labour this point any further, but just before I leave this judgment, I've got two other things I want to show you. In the speech of Lord Gorrell on page 757, he gives his version of the test we're talking about, and it's 2/3 of the way down the page on 757. There's a line that begins with the word case, and if, my lords, you could read from there till the end of that paragraph, you can see how he formulates the test. What I take from this is his phrase, to be dealt with. That's his version of the word govern, or Lord Atkinson's word germane. And in my submission, dealt with also brings together that idea of a physicality, that tangible connection, real tangible connection between the charter term and the loading, carriage or shipping or discharge process, which is slightly diminished and lost by the word germane, which if you loosely translate in the modern vocabulary might be approximate to relevant. And the reason why we say later judges in the Court of Appeal have added the word directly in front of germane, which comes from Lord Atkinson, is to try to introduce back that physicality, that proximity of connection between the charter term and the bill of lading process that is absent from the word germane on its own, because the word directly just appears in the authority later on in the Anfield with Lord Denning and later in the Miramar with Lord Diplock. There's no indication here. The final judgment, the final speech in this case is from Lord Robson. He doesn't give a further formulation of the test and doesn't specifically agree with any other speeches. But in his speech, I just want to highlight something slightly different. On page 760, the final substantive paragraph on that page. And if I could ask you just to read that to yourselves. I just draw 2 points out of this. You see at the beginning of this final paragraph on 760 a reference to the negotiability of the bill. So once again we see that characteristic of the bills driving their restrictive construction 150 years ago or so. But we also say, in a slightly separate point, as Mr. Blackwood addressed you on this morning, we would categorise general average as an ordinary legal remedy in Lord Robson's vocabulary here, which cargo interests case seems to deprive owners of. And what one can see here is a similar sentiment to that later reflected by Lord Diplock in the Gilbert Ash case in a general context, but here in the specialist bill of lading context, that one would need very explicit and precise words to achieve in a bill of lading a deprivation of an owner of its right to seek a contribution in general average from cargo. That's a slightly side point to my main reason for taking you to this case. As we can put away that case now, I'll just quickly pass over this because I think I've made this point already, but our submission based on Thomas and Portsea is, if you look back at across all of the speeches of the law lords in that case, including the fact that Lord Gorrell and Lord Atkinson agree with Lord Lawburn's speech, his use of governs and Lord Gorrell's use of dealt with suggests a majority view favouring this more physical link that I'm trying to persuade you should form the backbone of the test at this stage of the incorporation process. And to the extent that losing that understanding of the delineation of the test in this case has led to a decision in our case that the premium payment clauses are germane and therefore should be prima facie incorporated, then the law should be steered back towards that physical proximity. And then there's a side point in any event that this is an area of law where there's a proliferation of an unhelpful proliferation of different phrases to describe one concept, and it would be helpful to have some of those words cleared away and a refocusing on the critical word that sets the bar for incorporation, perhaps not quite as seismically, but in a similar way to the Fiona Trust and Priviloff case cleared away from the 2008 House of Lords decision, cleared away all of the different formulations for the scope of an arbitration agreement. So my Lords, on to application, having set out what we say the focus of the test should be, and we deal with application at paragraphs 89 to 91 of our written case, which is on pages 123 to 125 of the bundle. And as my exchange with Lord Leggett before the break, I expressed that in light of our perspective, that the payment of premium by the notionally uninsured party is a necessary but not a sufficient ingredient of the code. The real focus here between the parties is on whether those payment premium aspects of the Gulf of Aden clause and the war risk clause are incorporated in it. For this purpose, now moving on to that, it would be helpful to have those out. And they're at page 477 of the bundle. This is where they appear inside the recap. And it's the third part of, as you'll be familiar, the third part of the Gulf of Aden clause and the first part of the war risk clause that we're concerned with here. Now we say what these clauses do is they impose ultimate responsibility for payment of additional premiums on charterers via a reimbursement mechanism of monies first paid out by owners. You get that from the language of these costs being for charterers' account. And that reflects two things. First, that these additional insurances, at least the war risks insurances, are geographical extensions to the owner's annual policies. And so it fits that owners would procure the cover as an endorsement to an existing policy and then recharge that cost to the charterers. K&R is slightly different. There's no annual policy plus an extension, but because owners are insuring their own vessel, it makes sense that they would want to go to the market and choose the nature and extent of the cover that they want to buy. The second consequence of the language of charterer's account reflects how charter parties often work as a running account between the owner and the charterer, with some sums being payable and responsible by the owners and some by the charterers. In the context of a time charter, that running account is settled by periodic invoices, periodic hire statements, and in the context of a voyage charter by a final netting off invoice sent to you at the conclusion of the voyage. What these clauses do not do is make the transiting of the Suez Canal or the Gulf of Aden or the additional premium area conditional on the prior payment by charterers to owners of the premiums. That's what they do not do. Owners have no right to refuse to continue on the agreed voyage if payment is not made up front. What these clauses give them is a right...
That doesn't matter whether the payment has to be made up front or not, does it? The point is that it is a condition that the payment is... that an obligation to make the payment is assumed in return for the agreement of the owner to go through the Gulf.
In my submission, it could well be different if owners could refuse to go into the Gulf of Aden without prepayment of the premiums, because then that might be something you might say governs the carriage of the goods, because without the payment being made, the vessel, the owner would have a right, potentially, to not go through the Gulf of Aden until the monies are paid over to them. That's not how this clause works. Owners cannot turn around and say, I want my premium paid before I go through the Gulf of Aden. That's not what this clause does. And I make that point to illustrate these clauses do not have a practical or tangible effect on the way the goods are being carried. What has a practical and tangible effect on the way the goods are being carried is owners' agreement to proceed via Suez. Because when you proceed via Suez, the only way you can go is through the Gulf of Aden, and you have the map. Which
the owner will have taken out the extension before the vessel goes into the Suez Canal, would it not?
Usually.
I mean, it'd be mad not to, really, wouldn't it?
Usually, you can sometimes be held covered in war risks insurance context if you stray into an additional premium area without having previously taken out an extension and it can be retrospectively.
Well, they're not
practiced.
straying in this, are they?
No, that's not this. My understanding is not in this case.
So you would, the owner, I mean, we can take it that the insurance would be taken out prior to entering
Yes.
the Gulf of Aden.
Yes.
So if the owner says to Charterer, I want the premium paid now, before I enter the Suez Canal, what happens if Charterer doesn't provide the funds?
Well, we would say that would be, under this structure of charter, that would be an illegitimate decision by the owner to refuse to proceed with the voyage, because it doesn't have a right to refuse to proceed on the voyage.
What removes the owner's veto as to the voyage through the Gulf of Aden?
Sorry,
What, if anything, removes that veto?
Lord, I'm sorry, I didn't catch the beginning of the question.
So I say, what if you say that the owner can be the charterer can force the owner to have the vessel go through the Suez Canal into the Gulf of Aden without the charterer funding the additional premium. If the charterer said, I want to go through the Gulf of Aden, but I'm not paying you the premium just now, couldn't the owner say, well, you're not going through the Gulf of Aden?
Not under this framework of clauses, my lord. It doesn't.
Why not? What excludes that exchange?
The premiums are for charterer's account, but there's nothing here to suggest that the payment of the reimbursement of the premiums to owners is a condition precedent.
They're concurrent obligations. The concurrent obligations. They're not dependent on each other. The owner is promising to go through the Gulf, and the charterers are promising to pay the insurance.
And the
And
expectation.
each can sue if there's a default, but
Yes,
they can't refuse to perform if the other doesn't perform.
exactly. But a contrary situation where they could refuse to perform, where the payment, the reimbursement was a condition precedent to entry into the APA, may well be the sort of term that would fall within something that might govern the carriage of goods, but that's not what these clauses do. The obligation on owners to proceed via Suez, I can show you, is a few pages back in the recap on page 470.
470.
Two parts of the recap that show you why owners had to travel through Suez, or at least that was the Basel Agreement. The first part is about a third of the way, or a quarter of the way down the page, there's the word C/P speed, that's Charter Party speed.
I'm sorry, can you just give the page reference?
Yes, it's 470, so still in the recap, a few pages back. And we're looking at about a quarter of the way down 470. It's the Charter Party speed warranty. And it says 11 knots, WSNP, which is an acronym for Weather Safe Navigation Permitting, except Gulf of Aden transit, where Charter Party speed and masters, I think that's a typo for at, master's discretion. So you see from the Charter Party speed warranty, it's apprehended the vessel is going to be going through Suez and going through the Gulf of Aden. It's not linked to the war risks clauses. This is what the owner has agreed to do. This is the route it's following. And the other place you see the same thing is on page 471 under the heading financial. I think Mr. Blackwood or Mr. Hoffmeyer took you to this yesterday. You've got two possible freight rates at the top of 471. One to Singapore, one to Fujairah. These are the two destinations the vessel can go to. And then below that text it says all above via Suez. And as the map we gave you yesterday shows, if you go through Suez, you have to go through the Gulf of Aden to get to Singapore and Fujairah. There is no other option. And this is the part of the charter that explains the owner has agreed to go via Suez and not the longer route through around the Cape of Good Hope. These we accept are provisions that would be incorporated into the bill of lading as provisions that govern the carriage of the cargo. These provisions show you how the cargo is going to be carried from A to B, what route it's going to take. You do not get that from the Gulf of Aden clause and the war risk clause.
But what do you say is incorporated? I'm assuming there that the Suez costs, that doesn't include the insurance that we've been talking about. That's something different. I don't know what those costs are, but for a pilot maybe, but is the obligation on the owner to pay the Suez costs and the obligation on the charterer to pay expenses at load port, is that incorporated into the bill of lading?
Well, at the very least, we would say that the first part of this phrase...
Well, not at the very least. What is it that you say is incorporated?
Well, the whole phrase could be incorporated without manipulation. There'd be no reason to manipulate the word owners in that phrase at all. And there might be a debate in a different case about whether charterers here should be manipulated to bill of lading holder such that the bill of lading holder becomes subject for costs associated with this clause. But what's important is this clause tells the bill of lading holder, how is my cargo getting from A to B? Is it going the long way round or the short way round? And that does govern carriage, so we accept that would be incorporated.
Well, the insurance is part of the same regime. You can't have one without the other. They're a package.
Well, my lord, our submission is we don't agree with that. The financial consequences for the agreement to proceed via Suez, we say, are a matter referable to the terms on which the owners were willing to make their vessel available to the charterers for the particular voyage. That's a matter between the owners and the charterers. It is a classic charter party question and term, given that a charter party is concerned with the terms on which the owner will make the ship available to the charterer. The bill of lading is concerned with the cargo. Who's going to pay for the vessel's insurances for transiting through the Gulf of Aden, as agreed between the owners and charterers, has no physical bearing on how the cargo will be carried. That's already been
somewhat interrelated with the next point, because if charterers means charterers, then you can incorporate these terms without them doing any damage, as it were.
You could. And so there you get into the question of what happens with manipulation. Well, actually, Mo, if they're not germane, they're not incorporated at all. If you consider they're germane, then there's the question of manipulation and whether they just refer to charter or bill of lading holder. But if they're not germane, you never get to manipulation. That's the Miramar. You don't manipulate non-germane terms.
The fault may be entirely mine. Moving away from the bill of lading back into the charter party, I thought it was being suggested to us that the commercial deal was that the owner was giving up his veto in return for the insurance. Now, on your submission, that isn't right. Because what you're saying is the owner didn't have a veto once this chartered party was worded in the way it was, and are we to assume that on your interpretation the specific terms of the charter party overrode the inconsistent B4 terms? What is your client's position on this?
Well, I think it's what you said, my lord, that the owners did not have a right. They have already foregone their right, they've foregone their Clause 39 rights to refuse to enter.
So you're saying that the provision in Clause 39 has been superseded?
Yes.
I see, okay.
And I believe that's consistent with what I've been saying to you.
You've been saying, but I understood Mr. Blackwood to be saying that the commercial deal was that there was a contractual veto, and that contractual veto was being surrendered in return for the payment of the insurance. Now you're saying to me, well, there was no precondition that the insurance be paid. I just wonder if your two positions are consistent.
I'm not sure I see an inconsistency there. We're talking about the financial consequences, who's to pay for the insurances, and when that money is to be paid. And there is no clause in this charter which entitles the owners to refuse to go into the Gulf of Aden for any reason, including because premium hasn't been paid in advance.
Well, suppose the ship owner decided, or the master decided, to go around the Cape of Good Hope, so the whole voyage took much longer. And I think you would say, that would be a breach of the contract not only in the charter party between the owner and the charterer, but in the bill of lading between the ship owner and the cargo interests, okay? And suppose then, when the bill of lading holders say, why on earth did you go around the Cape of Good Hope? You were supposed to go through the canal and the Gulf of Aden. The ship owner said, because the charterer had, in anticipatory breach of contract, told me that they decided they weren't going to pay for the insurance after all, and so I was entitled not to go through the Gulf, or I couldn't go to the Gulf. Now, how would that affect the bill of lading holders' rights, either against the charterer or against the ship owner? Would the breach by the charterer of their obligation to pay the insurance premium release the ship owner as against the bill of lading holders from the obligation to go through the Gulf?
On that hypothetical, no, it wouldn't, because there'd be no obligation in the bill of lading.
You say they're concurrent obligations,
Yes.
so it wouldn't be, it'd simply be a breach of contract for which
Yes.
the owners would be liable.
Yes. Yes.
And there may be a cross-claim for the payment of the insurance, refund of insurance premium.
Yes. But the critical point I'm making here is this financial reconciliation between owners and charterers after the fact, at the end of the charter party, does not in real time affect, govern. It's not germane to it, doesn't relate to the carriage of the cargo. And that's why we say prima facie they're not incorporated. You don't even get to manipulation. And in the Court of Appeal, these points were elided. Lord Justice Miles's decision was that war risk clauses did govern the route the vessel was going to take. The clauses you see on page 477, his decision, which I can show you at page 145, the bundle, if we keep the clauses open, but also have, if that's possible, 145 of the bundle, which is the Court of Appeal's decision. The Lord Justice's decision on this germane point is in paragraph 48.
Well, when he says conditional on and inextricably linked with, I don't think he's making a point about one being a performance of one being a condition precedent to performance of the other. He's simply saying that they're mutual obligations given in return for each other, are therefore part of an integrated whole. And if you're going to have one, you're going to have the other.
Yes, but at the beginning of the paragraph, he says the reason he thinks the additional war risks in Kent was directly relevant, the agreement to pay the premium was directly relevant, because they governed the route that the vessel was going to take. And I say that's not right. The parts of the charter that govern the route was going to take are different. They're excised out of the war risk clause and the Gulf of Aden clause. The Gulf of Aden clause concerns the financial repercussions of the owners having agreed and bound themselves to go through.
It seems a very uncommercial approach to parse out separate out the obligations in that way. The point is that the owners were agreeing to go that route because in return they were getting their insurance premiums paid, and the two went together.
It may well do in the charter party, but my lord, the question here is whether it should go together in the bill of lading, and whether the payment obligation is still something that the parties to the bill of lading would have intended should form part of their agreement. And just like with demurrage, just like with a whole host of other types of clause which impose a putative payment obligation on the bill of lading holder, the general view is those sorts of concepts are not germane, because skipping ahead.
Well, to my mind, you have to look at it alongside the manipulation point, because
Yes.
If you were going to be saying, well, the cargo owners are paying for it, that would be one thing.
Yes.
If you're simply saying that it's going to be part of their contract that the charterers are paying for it, that's another.
Well, my lord, in that I agree that they go together. Of course, this is part of the stepwise process of incorporation which yields to the overall iterative process. I have to deal with them sequentially, but I completely agree that one looks at the ultimate question of incorporation in the round, and I don't shy away from that at all.
And unless there's some good reason to make charterers mean bill of lading holders, as long as charterers means charterers, then this point doesn't ultimately matter at all.
I agree, my lord. That's right. But I'm taking things in stages.
I know you are, but you're spending a long time on a stage.
Okay, well, my lord, with that indication, and naturally anyway, I'm ready to move on to manipulation. And now we deal with this at paragraphs 94 to 95 of our written case. That's where we begin to deal with manipulation. And just for the page reference number, that is at page 125 of the bundle. So, my lords, the starting point we would venture is that the language that the parties use in a contract ought not to be interfered with lightly on manipulation. And we do say that there is or there should be a presumption against manipulation unless there are indicia that positively support it as being consistent with the intention of the parties to the contract. And after all, even at this manipulation stage of incorporation, the singular concern is still ascertaining whether manipulation, or also referred to as substitution, is consistent with party intention. And, my lords, it's our position that the question of manipulation in this bill of lading specific context is consistent with and informed by the law's wider approach to correcting by the interpretative process linguistic mistakes in contracts, which also has as its aim the search for and preservation of party intention in circumstances where the words on the page are said not to entirely reflect what the parties meant. And the context for this submission, and where I'm about to take you, is Cargo's written case, at least, that the leading judgment in this area in the bill of lading context, the Miramar, should be, as it's said in their written case, revisited by your lordships, and that's at paragraph, it's at page 58 of the bundle. That's where Cargo invites you to revisit or reconsider Lord Diplock's decision in the Miramar. And what I'm going to show you is paragraph 94 of Cargo's written case. So I misquoted them. It's to review the decision and to create a situation where there's a presumption towards manipulation. And what I'm going to show you, my lords, is first the general position of the general law on manipulation from the Chartbrook case, and then I'm going to take you to the Miramar to show you that how Lord Diplock approached manipulation in that case, adumbrated in the bill of lading context, Lord Hoffman's later approach in Chartbrook. And so there is no reason to depart from or revisit in any way the Miramar. So Chartbrook is in the first volume of Authorities at page 845. This was a case between a property owner and a developer, and it concerned the proper interpretation of a clause in a contract pursuant to which the property owner was entitled to certain additional payments from the developer. The parties differed over the amount that was due. And the House of Lords allowed the developer's appeal, supporting the developer's construction of the relevant clause through permitting the correction of a linguistic mistake. And Lord Hoffman, who gave the leading speech in this case, set out how the interpretative process applies to the correction of linguistic mistakes at paragraph 14 of the judgment on page 856. Perhaps, my lords, you could read paragraph 14 to yourselves now.
I mean, are we in the territory of linguistic mistakes here at all? Are we not in the territory of understanding what the party's intention was in incorporating the terms of the Charter Party into the Bill of Lading?
Well, my submission, my Lord, is that the same principles apply to the correction of linguistic mistakes as should apply to the verbal manipulation of terms putatively incorporated into a contract, because both concepts have at their heart the search for party intention and the question whether the words the parties have used in the document match the intended meaning that those parties had when concluding the contract. So they're different contexts, but my submission is the test and the degree of difficulty that should be overcome before verbal manipulation is engaged in should be no different between the two processes. And I'll be linking what you see here in Chartbrook to the Miramar to show you how they are singing from the same hymn sheet, as it were. So the first half of paragraph 14 that I asked you to read relates the standard approach to the interpretation of contracts by reference to the ICS case. And it reminds us that a great deal of stock is put into the language the parties used, and that language will not easily be departed from. And the second half of the paragraph focuses on linguistic errors that can be corrected by interpretation, and records the well-known phrase that the court must reach a conclusion that something has gone wrong with the language before it indulges in manipulation. And what I would like to take from just at the end of paragraph 14 is the final sentence, where Lord Hoffman says, where something's gone wrong, the law does not require a court to attribute to the parties an intention which a reasonable person would not have understood them to have had. And we say that's a very good explanation for the key consideration with verbal manipulation in our case too. If charterer is not manipulated to bill of lading holder, you might ask yourself, is the effect going to be the attribution of an intention to owners and cargo interests under the bill that a reasonable person would not have understood them to have had? Only if that is the case would manipulation be on the table.
But
in other words, if the words
that must go without saying that if the clause incorporating into the Bill of Lading a certain provision is interpreted in a way which attributes to the parties an intention which they wouldn't have been understood to have had, then it's a bad interpretation.
Well, Lord, I agree. And if you agree with me that that question being posed by Lord Hoffman is a relevant question to ask in our context, it's then relevant to look at the test that Lord Hoffman applies for when you would depart from the words in that context with that overriding concern.
But isn't the risk that then that what happens is that the Bill of Lading holder gets the benefit of the obligations that the owner owes to the charterer, but then doesn't, because he gets the benefit of the fact that the owner has promised to the charterer to do all sorts of things with the carriage, with the voyage of the vessel, but yet they're not bound by the charterer's obligations because you just don't either don't transpose the clause at all, or you don't change the word charterer to Bill of Lading.
My lady, the answer is it's always going to depend on the particular clause you're dealing with and whether it would have been within the intention of the parties to the Bill of Lading that a Bill of Lading holder should assume that additional obligation to the owner, or whether it shouldn't. And in every different type of clause you're looking at, there may be a different answer to that question. Some obligations will more naturally be likely to be assumed by a Bill of Lading holder than others.
But aren't there rights also conferred by the clauses which are incorporated, rights that are conferred on the Bill of Lading holder
Yes.
by the clauses incorporated?
Yes, but some of those rights may only equally be expressed as owed to the charterer in those particular clauses, and you may not get manipulation in respect of those clauses as well. Again, it will always depend on the particular clause that you're dealing with.
Isn't the point a very simple one, that if the clause, when incorporated, makes perfectly good sense, reading charterer to mean charterer, then there's no reason to regard it as meaning anything else?
Yes, and that's
But
exactly...
if it doesn't make good sense, then you might have to read it as intending to refer to the Bill of Lading holder.
My Lord, that is our submission, and that's exactly what Lord Hoffman is saying at the end of paragraph 14.
Well, speaking for myself, I would have very much liked to have read Lord Hoffman on the principles to be applied to the manipulation of clauses taken from a charter party into a bill of lading, but I'm not aware that he ever wrote about it. And he certainly didn't write about it in this case, but I gather from what your submissions are so far that we do have the benefit of Lord Diplock on this topic. So where the House of Lords has spoken on this topic, isn't it more helpful to go to that rather than this argument by analogy, the analogy being, I think, pretty imperfect?
My Lord,
Because in the final sentence on which you rely is a principle that is not confined to the existence of a mistake or to manipulation. It is a general rule of contractual interpretation.
My Lord, the submission I face from my learned friend is that the approach Lord Diplock took in the Miramar is out of date and inconsistent with the modern approach to incorporation and manipulation.
Let's see what he says and see whether we think it is out of date.
Well, my Lord, you didn't hear from Mr. Hoffmer on it yesterday, but yes, okay, I can skip to the Miramar if you would like me to.
I think that is the invitation you're receiving.
It's in the Core Authorities bundle, page 703. And now what I want to show you here is that although substantially predating Chartbrook, the Miramar takes entirely the same approach, and that is my answer to my learned friend's submission that you should reconsider or depart from this authority, which he says does not reflect the modern approach to the interpretation of contracts. So, my lords, this was a claim under a bill of lading by owners Miramar against Cargo Interests Holborn Oil Trading Limited for demurrage earned by the vessel at the discharge port. And the issue was whether the provisions of the charter pertaining to demurrage had been incorporated into the bill of lading so as to make the consignees liable for it. And that question turned on whether charterers should be read as consignees in the bills of lading, having been accepted prima facie that a term concerning demurrage was germane. And the only speech was given by Lord Diplock, but you can see from from the end of the judgment that the rest of the law lords in this case agreed with him. That's Lord Scarman, Lord Roskill, Lord Brandon and Lord Brightman. That's from page 709. So we say this is despite being just delivered by
Which page are we going to?
So just to show you who agreed with Lord Diplock's speech on 715, you can see the list of the other lords that simply agreed with him. So it's a powerful judgment in that respect. And of course this authority has stood for some 40 years, since 1984. Now first I want to show you the context in which this appeal came before the House of Lords. And from that you can look to the bottom of page 709 by the letter G. So on 709 between G and H, you can see Lord Diplock's referring to cases called the Merrick and the Anfield, which are both Court of Appeal decisions, which were relied upon by the High Court and the Court of Appeal in the Miramar case as the starting point for their analyses or in the Miramar case. And you can see over the page on 710 that the starting point in those cases was thought to be that a clause that was held to be directly germane to the shipment, carriage and delivery of the goods was to be treated as incorporated even if a degree of manipulation is required to make the clause fit a bill of lading. And the implication there was thought to be that those cases were suggesting manipulation should follow the finding that a clause is germane without much ado. And we understand that to be what Cargo Interests suggest is the position in the Anfield and the position that you, my lords, should consider is correct instead of what we see in the Miramar. Now, the first point to note is that the Merrick and the Anfield, as Lord Diplock notes between A and B on page 710, were strictly obiter with respect to wider questions of incorporation and manipulation because they only concerned the incorporation of arbitration agreement. But, my lords, the really striking point for us at this stage is between E and G on 710, where Lord Diplock explains why permission to appeal was given in the Miramar. So page 710 between E and G. Lord Diplock explains here that the only reason permission to appeal was given was not because there was any particular doubt about the correctness of the Court of Appeal's decision, but for the very reason that the House of Lords wanted to examine the correctness of the dicta in the Merrick and the Anfield concerning the extent to which verbal manipulation was permissible. So that's the context for how this case reached the House of Lords.
Not a very promising basis for the appellants.
Perhaps not, my lord. Now, just to show you then what Lord Diplock decided, this appeal having now come before him, and I'm just going to build this slowly by first going back a page to 709 and to letter D. These are the building blocks of Lord Diplock's decision. And there's a line just 3 lines above D that starts ex-envoy 1969. Could you read from that to the end of that paragraph where the letter F is, please?
Starting at letter?
Starting just 3 lines above letter D, the sentence that starts ex-envoy 1969 in the margin, down to the end of, down to F, the end of that paragraph.
Oh, I see.
The point being made here is that in respect of the one vessel and one overall cargo being carried by it, as apprehended by the Charter, various permutations may arise with respect to bills of lading. That includes multiple loading ports, multiple bills of lading arising in relation to parts of the cargo, with parts of the cargo potentially being discharged at different ports. And Lord Diplock states the answer to the interpretive question cannot differ depending on any of these permutations as to how bills may arise in accordance with the carriage. And my lords, these concerns apply just as much to our case as they did in the Miramar, and just as much generally today as they did in 1984. Over on 711, at the bottom of the page just after G, we have another aspect of Lord Diplock's reasoning. And perhaps, my lords, you could read that just over the page where that paragraph ends.
What, the paragraph starting the construction placed?
Just by the letter G, so it's on page 711, and the first words are
711, sorry.
so if the owners are right. So here we can see Lord Diplock's concern that in light of the negotiable nature of a bill, every future consignee to whom a bill covering part of a cargo is negotiated becomes personally liable to pay not only freight but also any further sums, in this case demurrage, which are unknown and unknowable. Those 2 parts of the judgment I've taken to you are the background concerns that Lord Diplock had. And we say, in respect of manipulation, they are both generally, in the modern day, and in relation to this case, just as valid and legitimate as they were in 1984. Returning to the judgment, we have the first part of Lord Diplock's determinative reasoning on page 712 between letters A and D. I'm going to just break this down into sections. There's the first 5 lines between A and D, where Lord Diplock decides that the commercial consequences that he's outlined are so unpalatable from the point of view of the consignee that it just can't be said that becoming subject to those obligations would reflect the intention of the parties to the bill of lading. And also this is coming back full circle, as we always do, to the fact this is an interpretative process seeking to elucidate party intention, a very modern concept. He then goes on between letters B and D to highlight a series of practical considerations that reinforce his view as to the party's likely intention. That includes points similar or the same to those we've made in writing, and those that Lord Justice Males and Sir Nigel Tier found compelling in rejecting manipulation in the Commercial Court and Court of Appeal. The same questions arise in our case, how there's no mechanism in the bills to determine how liability between separate consignees, if there have been separate consignees, was to be resolved, both practically and on what legal basis. And there are also other questions raised in our case, such as what happens with respect to the liability of a consignee whose cargo has been discharged before the vessel transits the high-risk area. If that was
could that happen in this case?
It could have happened if the charterers had instructed the owners to do that and they'd agreed to do it. But one's thinking here of broader propositions about complications that could arise with the incorporation of an obligation to pay insurance premium rather than specifics of this case, in addition to the problems that might arise with a demurrage obligation. For example, what would happen if one consignee's cargo was discharged to a port within the APA, the additional premium area, and then there was to be a piratical seizure after the vessel had delivered that party's cargo and the vessel had moved on further into the APA? How would liability be apportioned between that bill of lading holder who didn't have a cargo on board the vessel when the piratical seizure took place? And
I mean, is this right that you should detach this issue of construction from the charter party and the intended voyage in this case? This was for Jera or Singapore,
yes,
both of which are after the high-risk area.
But I'm postulating problems in principle with incorporating.
No, but I mean, that's true, but that could arise in a different case. Well, what about this case?
Well, in this case, the problem, I think, my Lord, in my submission, it is right to consider the possible permutations that could exist. For example, multiple bill of lading holders, even though there was only one bill of lading holder in this case.
Well, we could have 6, couldn't we?
You could. And the question of construction of the incorporation of the bills of lading can't depend on how many bills of lading we had in this case. It can't depend on necessarily whether or not there was an instruction to discharge cargo if you had a multiple bill of lading.
It's enough for your purposes that there are 6 in this case, and they could be held by different people and could be negotiated a number of times.
Yeah, they were negotiable. They were negotiable, and any one of those, if those bills had been negotiated to another party, they could have asked for their cargo to be discharged at a different port. And
could they?
A discussion about it.
I'm sorry, could they?
It seems to me they could at least ask, and it would be up to. Would be a discussion.
No, it's not part of any contractual arrangement that they'd be discharged anywhere else.
No, there'd have to be a fresh agreement.
But it could, I mean, do you accept that it's got to make sense in the context of this charter party, which is a single voyage charter party, and therefore there may be different outcomes to the incorporation or manipulation process from what there would be in a 5-year time charter or a bareboat charter?
Yes, different contracts could lead to different results.
Yes.
But the permutation of
we don't have
how
to
the
come
bills
up with
are
an
issued.
answer as to whether these are incorporated or not, which stands for every kind of charter.
Yes, I think the point I'm trying to make is that the exact permutation of how the bills came to be issued in this case isn't determinative of.
I mean, I just have in mind that the Court of Appeal thought that the difficulties, the practical difficulties arising in this case with 6 bills was enough.
Yes,
are you suggesting that's not enough?
No, I'm just.
You're sort of piling pillion on ossa.
Yes, I've just emphasised. What I'm trying to emphasise is how the concerns that Lord Diplock had are just as viable as they are today, in addition to the reasons that the Court of Appeal gave. So, not limiting myself to those.
I don't think you need to make it terribly complicated. I mean, if there's no particular business reason to expect the cargo interests to be paying insurance which the charter has agreed to pay.
My Lord,
And add to that the complication that will be involved in trying to work out how they would do it,
yes,
how they would apportion it.
that's a
Yes, because I mean the owner has the benefit of the charterer's covenant already to pay, and how does the bill of lading owners concurrent parallel obligation come into play at all?
Yes, well, I'll stop making life more difficult for myself then, and I'll just make one further point on the Miramar before I move away from it. And this is in response to a way in which it seems to me my learned friend tries to distance the Miramar from our case, and that is to look at Lord Diplock's supplementary reasoning on between letters E to F on the same page that we were on.
Which page?
So it's page
7112.
7. Sorry, yes, I just put the bundle down and.
We were on 7112.
Yes, thank you.
He's talking about a 19th century case. We don't need to look at that, do we?
No, I think it's 714 that I had in mind between letters E and F. This is the point that we've discussed a few times variously, the idea that if the charter party refers to bill of lading holder and to charterer, that might be an extra impetus against manipulation because the parties have already indicated that they are able to select the right word. And I think my learned friend's submission here is, having directed you to various clauses in the charter party where different names are used, that is a less strong position in our case than it was in the Miramar, where there were very clear demarcations. And I accept that the clauses in our charter party are different, and we haven't relied very strongly on that point at all. But what I want to show you is that that concept was very much Lord Diplock's alternative and supplementary reason for refusing manipulation. It was not the primary reason. You see that from E to F on 714, but also...
I thought you'd be wanting to focus on the top of page 714, where it says, I can see no business reason for verbal manipulation in any of these clauses. And then he goes on to say, it makes perfectly good sense with the words as they are, as they're written, without having to interpret them as a mistake or as
Yes.
meaning something else.
I was going to take you to those before I sped up, but that was, of course, part of my thing. But the final point, just to reinforce what I've said about the different references to parties being an alternative point, is on 715 by letter D, where Lord Diplock puts the point beyond doubt. It's in the middle of the line by the letter D. He says, I regard it as more important that this House should take the opportunity of stating unequivocally that where in a bill of lading there is included a clause which purports to incorporate the terms of a charter party, there is not any rule of construction that clauses in the charter party which are directly germane should be manipulated. My Lords, that is the part of this judgment that my learned friend attacks, and he says there should be a presumption of manipulation, and Lord Diplock is saying that's not right. At the very least, he's saying there's no presumption either way, but really what he's saying here, if you look at it in the context of Chartbrook and generally the idea that the words the parties use should be the starting point unless there's a good reason to depart from them, there is a presumption against manipulation subject to the overall party intention cross-check. So, my Lords, that is the law on manipulation, and I'll just give you the reference in our written submissions where we apply the law on manipulation to our clauses. It's paragraph 97 of our written case, which is on page 128. With one eye on time, I won't just recite those points to you now, but we've set them out. We've set them out extensively. And we say for all of the reasons set out there should be no manipulation in this case. In particular, the analogies that my learned friend draws with general average, we say are inapt, because general average does not, the imposition of an obligation to contribute in general average does not suffer from the same sorts of problems that that Lord Diplock was concerned with in the Miramar, because the general average regime itself explains how disputes are about who's meant to contribute should be resolved, whereas there's just no framework for that as between separate bill of lading holders or successive holders of the same bill of lading who have it negotiated to them one after the other. Well, Lords, that's what I wanted to...
That didn't bother the tribunal, though, the expert tribunal. They seemed to jump over that problem.
They did. Sir Nigel Tier and Lord Justice Males didn't. What I would say about the expert tribunal is, indeed they're expert, but they are lawyers just like everybody else. They weren't commercial people. Sometimes you get trade tribunals who are involved in the trade. The tribunal was composed of 2 KCs and a very experienced lawyer, maritime arbitrator. So they're, to the extent the submission by my learned friend is that they were more in touch with the realities of the market than Sir Nigel Tier, one of the most experienced maritime judges, and Lord Justice Males, again, one of the most experienced maritime judges, we say isn't a good one, and the tribunal just got it wrong. Well, that's all I wanted to say about manipulation. I'm going to deal very quickly, finally, with having now dealt with the Route 2 long way incorporation arguments, my learned friend's Route 1 argument, which you'll remember that I indicated to you at the beginning was this idea you could incorporate an implicit understanding almost as a tangible concept in itself. And we say that's not right. You incorporate terms, not intentions. And from first principles, that must be right, we say, absent any authority, because the parties to the bill of lading are different to the parties in the charter. The process of interpretation is designed to objectively ascertain the intentions to the parties of the particular contract you're dealing with. So even if all of the same clauses, the war risks clauses present in the charter, were incorporated over to the bill of lading, which in fact neither party says is the case, it wouldn't be principled to automatically decide that those clauses give rise to the same implicit meaning in effect in the bill of lading between different parties as they have done between the parties to the charter. The same words or terms construed against a potentially different factual matrix by reference to a different kind of contract with a different commercial context may mean different things and give rise to a different implied understanding or even none at all, which is what we say the case is. But this isn't completely free from authority. There is a Court of Appeal decision we say puts the position beyond doubt. It's at page 1258 of the authorities bundles in the second volume. It's a case called the Varenna Court of Appeal decision. And this is one of the many cases in the long line of authorities delineating the incorporation of arbitration agreements into bills of lading. That's what it's concerned with. In the course of that decision, on page 1278, Lord Justice Oliver was faced with a submission that in substance required him to consider the intention of the parties to the charter party as a prelude to incorporation, so 1278. And the particular point where his point is made is around letter D in the report, but I think it might be more helpful for you to read from A all the way down to D to understand the context in which he was making his comment. The context behind what Lord Justice Oliver was saying here was a submission that you could look to the terms of the charter party as a prop to incorporation into the bill of lading. The intention of the parties to the charter party was to incorporate, therefore that should help you, and he was rejecting that. And in particular what he said was the purpose of referential incorporation is not, or at least not generally, to incorporate the intentions of the parties to the contract whose clauses are incorporated, but to incorporate the clauses themselves in order to avoid the necessity of writing them out verbatim. The meaning and effect of the incorporated clauses has to be determined as a matter of construction of the contract into which it is incorporated, having regard to all the terms of that contract. We say that's on point for what my learned friend is contending under Route 1, because it necessarily requires you to form a view about the intention of the parties to the charter party and transpose that over to the host document, the bill of lading, and we say that's impermissible. This comment from Lord Justice Oliver was later picked up and approved of by Lord Justice Bingham in a case called the Federal Bulker, which I can very briefly show you as well. This is on page 949 of the bundles, in the first authorities volume.
Can you just give that page again, please?
Yes, it's page 949.
Thank you.
And you see it, the point being made at the bottom of column 1 through to the end of the first paragraph in column 2 by Lord Justice Bingham. And then later on in the same judgment at page 953, he cites Lord Justice Oliver's comment verbatim at the about 2/3 down column 1 on 953. And my final point to make good this submission is that Lord Justice Oliver's comment there was picked up later and approved by Mr. Justice Gross in the Sabotti case, which I took you to earlier. I won't take you back to it, but the reference is page 1228 of the bundles. And the only reason I refer you to that, even though it's a first instance decision, is that it's much more modern. It's 2003, so it shows that the position Lord Justice Oliver was taking has been approved of in the modern era of contraction interpretation and is not something that is no longer considered to be correct.
We should remember that the modern era of interpretation can be said to have started with Lord Wilberforce's speech in the Reardon-Smith case.
Yes, my lord, you might be right.
Which was decided some years before the Miramar, let alone others of the authorities you've referred
My
to.
lord, I accept that. The way the parties have looked at it, the cut-off point in this case is ICS in 1998.
Yes, I think that may be a mistake.
I think that is a mistaken analysis. ICS may have been a high watermark,
Yes.
but the modern approach really goes back to Lord Wilberforce in the 1970s. And while the tide may have been as highest at ICS, and some people may say there's been a certain receding from that, the basic methodology that was established 50 years ago.
But if you incorporate a term from the Charter Party into the Bill of Lading that imposes an obligation on the Charterer, and you don't manipulate it to read Bill of Lading holder for Charterer, what, if any, is the effect of that on anybody's contractual rights and duties to anybody else?
There are a few possibilities. It could serve as a record of the agreement between the owner and the charterer, which might help the owner and the Bill of Lading holder delineate their own responsibilities. If the owner comes to the Bill of Lading holder and says, you must pay me war risk insurance premium, the Bill of Lading holder can point to the contract and say, no, the charterer is going to pay you that. It may also vitiate an implied term if the owner was to say, well, there should be an implied term that you must pay me war risk insurance premium.
But if,
you could point to that.
Putting it another way, if there's an obligation in the Charter Party that's placed on the ship owner, and that is then incorporated into the Bill of Lading, but not manipulated, so that charterer doesn't mean bill of lading holder, presumably it doesn't then mean that the owner owes that same obligation to the bill of lading holder.
Agreed. Yes. So the bill of lading holder can enforce the right that was recorded there, which is just a record of an agreement made in another contract.
They can't enforce it.
Can't.
No.
I mean, if we are with you on the point that charterer means charterer in the clause, even if it's incorporated, then the question becomes whether the fact that the charterer has agreed to pay the owner's insurance premium is a reason to treat the cargo interests as having somehow given up their or somehow having shed their liability to contribute to general average. And one can't begin to see any reason why one should lead to the other.
My Lord, I agree that was my final point, which I'll deal with just in 2 minutes to take advantage of the 5 minutes that my Lord Hodge gave me.
Well, we won't interrupt you in the final 2 minutes.
There are 3 reasons why my Lord Legate's question is, or what it was positing is what we say is the case. First, the war risk clauses don't mention cargo interests at all, so one is left with inference or implication into an already implicit understanding, absent any contextual or background evidence, to suggest that cargo interests should take the benefit of an agreement said to arise from the relevant clauses. Second, it's charterers, absent the manipulation, who are responsible for paying what may only be a portion of the insurance premium, laying natural and prominent focus on the extent of the code as to operate between owners and charterers. The orthodox position being across all of these implied code disputes in the shipping context, that it's the payment of premium, that personal obligation to pay premium, that invites you into the code arena, subject to the other additional requirements that are needed to be established. There's never been a case, so far as we've been able to find, where an ostensibly bilateral implied fund agreement has been extended in effect to an unnamed third-party beneficiary who wasn't obliged to pay the premium. That's the case both inside and outside the shipping law context. Cargo Interest's answer to these points is that you must read the code nevertheless as being for cargo's benefit, because it was cargo who stood to reap the benefits from any avoidance of a GA contribution occasioned by the ransom event. We say that is a bootstrap submission after the event. There's no indication from the war risks clauses themselves that any, or the central or even any focus of the code is contributions in general average, even if you find that the code in principle could extend to general average. General average isn't mentioned anywhere in the clauses said to give rise to the code. As Mr. Blackwood said this morning, it is mentioned in a separate clause without any caveat or cut down. That's clause 41. We say general average is not what defines the code's ambit or focus, it's just a feature, if you, with cargo interest this far, of its scope. A natural approach to the code in situ in the charter would be that it was primarily intended to cover the normal instance of a voyage affected by kidnap and ransom risks in the Gulf of Aden, which could lead to litigation between owners and charterers, which do not just mean general average. There could be a host of physical damage to the hull and machinery of the vessel, safe port warranty disputes, detention and delay to the vessel inside the APA, and all of those factors could more likely be the focus of the code, rather than it having to be general average contributions from an unnamed class of beneficiary. And we say that's the reason that Lord Justice Mills was right to apply the Gilbert-Ash principle and other principles similar to it that we've addressed you on in the course of our submissions. Lord, unless there's any questions you have for me, that's all of the submissions I wish to make.
You're now into injury time in any event, so thank you very much indeed. Mr. Hoffman.
My Lord and my Ladies, I will deal with a few points just by way of picking up matters, and then I will conclude with some more general observations at the end, if I may.
Thank you.
I've already provided the document on references to cargo parties in the BP Roy form. I also promised some pages in relation to dealing with general average. These have been sent to the registry, but these are paper copies which just give an indication as to the contributors to general average being cargo, ship and freight.
Again, has Mr. Blackwood seen this document?
He's seen all of these documents, yes. We've also handed up, in response to a request from Lord Hamlin, a document which shows the Charter War Risks provisions.
I understand that Lord Hamlin will be able to obtain this electronically, is that right? It's been sent to registry?
It's all been sent to registry, yes.
Thank you. Lord Hamlin.
I can't hear Mr. Hoffmeyer. Speak in the microphone, please.
Sorry, can you hear me now?
I can, yes.
I do apologise. Thank you for pointing that out. A reference was made by Lord Hamlin to paragraph 29 of the judgment, page 155, and the question was raised whether that was an accurate reflection of what had been said by the tribunal. In our submission, it was a misunderstanding on the part of the judge and is not an entirely accurate reflection of what had been said by the tribunal. The relevant paragraph in the award is pages 184 to 185, paragraph 56.
Sorry, this is, so in the judgment it's page 155.
Judgment page 155, award page 184,
And the
paragraph 56.
Paragraph on 155 that you're referring
sorry, paragraph 29 on page 155.
Yes, okay.
I'm sorry, I'm taking it too quickly.
No, don't worry. So, yes. So, C award, paragraph
56, page 184 to 185. The analysis of the tribunal in the first sentence concentrated on demurrage or demurrage type obligations, and that can only have concerned the first paragraph of the Gulf of Aden clause and the reference to time in the second paragraph. And it's for that reason that we have set out in the document we provided to you that the bulk of the second paragraph of the Gulf of Aden clause in our submission would be incorporated.
I thought in the Miramar, we were just looking at it, the point was not that they weren't incorporated, the demurrage clauses, but that they applied to the Charter and not the bill of lading holder.
That was the decision in the Miramar, correct? Yes, and
that was what prompted me to ask, well, what difference does it make then to incorporate them if you don't manipulate them? It doesn't seem to. It may, as Mr. Kaplan said, be useful in interpreting some other clauses, but it doesn't of itself impose any. Make the parties to that obligation liable to anybody else for failure to fulfil that obligation.
Yes, my learned friends, the difficulty with his argument is that it means if one is incorporating a charter party that doesn't impose obligations on a bill of lading holder or a consignee, then you will never have the obligations which it was the intention of the parties to incorporate into the bill of lading. The whole purpose of a short-form bill of lading is to incorporate the terms from another contract. It's not to rely upon that other contract as some sort of background information. It's in order to allow the owner liberties and exceptions, clause 39 by way of example. It's to impose obligations on the owner, and likewise the bill of lading holder assumes obligations. Oh, I'm so sorry. Thank you so much. It's not an empty gesture. That's the difficulty that one faces, and if one otherwise adopts one has to the approach is not a mechanical one. It's got to be done on a sensible basis in order to ensure that the types of obligation which one would expect to be on an owner owed to a bill of lading holder and owed by a bill of lading holder to the owner are there. Equally, the exceptions which are provided, the liberties which are provided are shared. Otherwise, it's an empty gesture. I've handed up the extracts from the textbooks on general average, so I'll move over that. Just so that we can be clear on the insurance code for which we contend, and as found by the tribunal and the judge, is that the owners would look first and solely to the additional insurances for losses covered by those insurances. So it was an undertaking by the owners, and that was it, to look to first and solely to the additional insurances. Can I then move on to the matter of clause 39, which is to be found in the bundle at page 508 to 510. And I have to say, with respect, that the owner's case in our submission is somewhat in disarray at the moment, and indeed I'm not quite certain what the owner's case is in relation to clause 39, and I should say that it is an entirely new case so far as I'm concerned. It's not a case that I have understood, articulated in any way, shape or form before. I apprehend that what has happened is that my learned friends have picked up on a statement made by Lord Justice Mayles in the judgment in the Court of Appeal, and have sought to read into that judgment more than the Lord Justice was indeed saying, and that was paragraph 48 on page 145. And before I ask you to look at the paragraph, so far as I could understand it, my learned friend Mr. Blackwood made the submission that there is no direct connection or interface between clause 39 and the Gulf of Aden clause, and related to that, that clause 39 is of no application to the high-risk area unless, in his words, there is a change of circumstances. Now, all of this is entirely new, as I say, but it appears to be built on this paragraph. It's not in our submission what Lord Justice Mayles was saying. In this paragraph, what he was seeking to articulate was that if the owner chooses to proceed by this route and to not exercise its liberty, which it would have under clause 39, but for the choice, it would have been, perhaps let me take it more slowly. He says in the second sentence, the route which the vessel was to take, that is to say through the Suez Canal and therefore through the Gulf of Aden rather than around the Cape of Good Hope, was plainly of direct relevance. The ship owner's agreement to proceed by that route, and I think a great deal has been put on the word agreement, because it's now being suggested, it seems, that that was an agreement made at the time the charter party was concluded. And in our submission, there's no basis for that at all, because there wasn't even any additional insurance at that time. What it meant was the ship owner's choice to proceed by that route and not to exercise the liberty to deviate around the Cape, which clause 39 of the BP Voy form would otherwise have allowed, was conditional on and inexplicably linked with the availability of the insurance and the charter's agreement to pay the premium. And it seems that it's now being deployed as a a reason why the owners can say that Lord Roskill's first factor is not in play in our case. Now that's not been said before, but there are in any event numerous insurmountable difficulties with any of these new approaches. First, it's not clear whether it's being suggested that Clause 39 has no application at all to the voyage. It simply has no application whatsoever because of the Gulf of Aden clause.
Well, I don't think it was just the Gulf of Aden clause. I think it was being suggested in the second speech by the respondent that the terms of the Charter Party, where it spoke of the route being by Suez, had in some way ousted Clause 39.
Well, with due respect, whenever there is a planned voyage from A to B, even if that were the case, and we don't accept that, but even if there was, and the Charter contains liberties in the event of war risks arising.
That is your case. Your case is the route is fixed, but the liberties remain.
The liberties must be there. What if, on approaching Port Said, the Israelis had attacked as they did in the previously, and there was a war taking place over the Suez Canal, or if Aden had started a war against Eritrea or whatever in the Red Sea, and in those circumstances it's inconceivable that because of the Gulf of Aden clause the owners would have lost the right to rely upon Clause 39 and to say no, we're going via the Cape of Good Hope because this is dangerous, there's a war there.
I can see that, but suppose that on the day after entering into this charter party, owners had said, oh, actually, we've changed our mind. We're not so keen on going through the Gulf of Aden after all. We're now going round the Cape of Good Hope.
Yes.
That would seem ridiculous commercially.
Well, it would if there were no reasons for that.
Yes, exactly.
It depends, but then that raises the question, that raises the second problem with it, is what are the circumstances that one must look at for the purposes of deciding whether there's been a change of circumstances. And the difficulty with that is that Clause 39 leaves it to the discretion of the owners and the master to make that decision. It's not a matter which is an objective, there is leeway for them, and if the master formed the view that he may not have been involved in the discussions in relation to the Charter. Based upon information which he was given post the Charter, he may have decided it's now too dangerous for me, despite all of this, to take the vessel through the high-risk area. There may be more pirates acting. I've been given some new information. We don't know what the information is which would have set the circumstances at the outset in order by which to measure whether there's been a change in circumstances. So the second point is it's not clear what legal basis the owners suggest that Clause 39 is of no application to the high-risk area or to the voyage, if that's what they're saying. Third, he says it becomes operative in a change of circumstances, but he fails to explain what a change of circumstances is. One extra pirate boat out today, does that make a difference? Nor does he explain what the base is by which to measure change in circumstances. What are the base circumstances, point I've made? Nor does he explain at what point in time the circumstances are to be measured. What if circumstances have changed on the ground but are not known to owner's head office, but they're known to the master based on information that he's provided with? He will also have to go on to explain what this means for the bill of lading contract. Is he suggesting that the submission applied in the bill of lading contract as well, that Clause 39 doesn't apply at all in the context of the bill of lading contract? All in all, the submission that Clause 39 is of no application, however one costs it, is a bad one. It is provides the owners with liberties, it provides them with exceptions, it provides them with an alternative choice in circumstances, so long as they can bring themselves within the clause. And it's not in any way by reference to whether or not there's been a change in circumstances. So Clause 39 is of no application, is a bad point, and the consequence is that the owners retained a veto at all times, and Lord Roskell's first point applies with force in this case.
So your case is that as soon as they'd agreed the recap terms, they could immediately have said, well, because this will involve us going into an area of war risks, we're actually going to go around to the Cape of Good Hope after all, even though nothing has changed since last minute when we just agreed to go through the Gulf.
They could do that if they could point to the fact that the master or the owners had formed the view required by Clause 39. It's for that reason that the purchase of insurance was left until later. Well, the insurance wasn't purchased at the same time as the contract was concluded. It was purchased later, and that meant that the owner retained the flexibility. The owner could decide that they weren't going to buy this additional premium.
So
wasn't there automatic exposure to war risks just through agreeing to go through the Gulf of Aden at that time?
There was a exposure to, well,
I mean, the condition in 39.4 was satisfied from day one, wasn't it? That the vessel was likely to be exposed to war risks on part of the route.
Yes, that is absolutely right. But the owners were not agreeing to give up the right to go via the Cape if war broke out in the Mediterranean.
Well, but you're going further, as I understand it. You're saying they were never agreeing to do anything else. They were keeping, in fact, although it refers to Gulf of Aden, on its proper interpretation, the contract was one for them to take whatever route they wished. Because going through the Gulf, they'd be exposed to war risks, and so Clause 39.4 was triggered as soon as the Charter Party came into existence.
Clause 30, the Gulf of Aden clause gave the owners a liberty that if they took that route, then additional premium would be paid for. That was all it was saying, that if they went through that route and they incurred additional premium, that would be paid for.
It just seems unlikely that charterers thought they were buying a pure hope that owners would decide in their good offices that they were going to go through the Gulf of Aden, well, despite having no obligation whatever to do so in the circumstances, without any need for a change of circumstances. But that I understand to be your interpretation. It was what charterers were paying for was a hope that owners would not decide to exercise their right under 39.4.
Well, the alternative to that is, what if there was the appearance of two piratical boats in the Gulf of Aden rather than one? Have they lost the right now? Assume 100 piratical boats had suddenly appeared in the Gulf of Aden. Is the suggestion that they've lost their rights under Clause 39 altogether? They've got to go through. If there had been a war had broken out in the Gulf of Aden, they've lost their rights and they've got to go through.
Yes, but you're invoking a change of circumstance, but you've just told us, I think, that there's no certainty as to what amounts to a change of circumstance.
Well, but that's I'm using that as an answer to my Lord Legate's.
To say that you don't need a change of circumstance.
Well,
because it's difficult to formulate what would amount to one, you don't have to have one. It's just a pure choice option on their part.
That is what Clause 39 provides them with.
So you say that they have that liberty, they have the option, but what's new is that if they decide to exercise that option, then they can take out insurance, and that insurance is for the charterer's account.
Entirely. That's exactly what we're saying.
That's your position. What's being said against you by reference to pages 470 and 471, the reference to the charter party speed and by reference to the financials,
Yes.
is that it was pre-agreed to go by Suez.
No, provision was being made that if it did go by Suez, those would apply. That you would expect to see those clauses in the charter party, even if it wasn't going to go through a high-risk area. You would expect provision to be made that the vessel would go on this particular route, or the route that required was the route of dispatch. But that doesn't oust in any way clause 39. The mere fact that the anticipated route is this, that the clause can still be relied upon if the circumstances envisaged by it give a right. And so, yes, of course, they anticipated that they would go through the Gulf of Suez, and that's why they put in the Gulf of Aden clause, and that's why they put in the war risks clauses, so that if they paid additional premiums, because under their insurance contracts, they weren't allowed to go through the Gulf of Aden. That's the background. They weren't allowed to. They were excluded areas. There was no insurance coverage if they went through the Gulf of Aden. And therefore, they're agreeing to this voyage. They're not giving up their clause 39 rights if they arise, but they're agreeing to this clause so that the additional premiums which they're going to be required to pay to go through the Gulf of Aden will be paid for by the charterers. And in addition, because of the particular problem of piracy at the time, they wanted specific piracy cover, and they wanted the charterers specifically to pay for the piracy cover.
Thank you.
Sorry, I've
I better let you get on with your point.
No, I'm sorry that I've taken...
That's an important point.
My Lady Rose asked whether if a loss caused by a war risk arose, would it not always fall within a general average? And Lord Hamlin noted that a total loss would be covered by the insurance, but would obviously not give rise to general average. I think that point was accepted, but Lady Rose asked a further question, then asked about the kidnap and ransom cover. Can you ever have a kidnap and ransom loss that would not also be general average? And with respect, that is a highly pertinent question. The answer to it is yes. If you're on a ballast voyage, that will always be the case, but we're dealing here with a laden voyage, so let's look at that. If the pirates had come along and they had boarded the vessel, but they'd been fought off, but they did manage to take 2 crew members with them, and the vessel then went on to its destination, and in order to get the crew members free, a ransom had to be paid. That would not be a general average a matter at all. And related to that were questions again by my Lady Rose on whether owners would be left without insurance cover if an insurance fund was agreed. And this related not to the first 5 million, but to the 2.7 million which was covered under the hull and machinery policy. And again, the answer to that question is no. And the reason for that is because my learned friend showed you the general average coverage under the policy. That's clause 11, page 563. In circumstances where an owner and a charterer have agreed to an insurance fund and that there will not be a general average recovery, the owner has a full recovery under the sue and labour clause, which is clause 13, because there will be expenditure incurred in suing and labouring for the purposes of protecting the vessel.
Which clause was that?
It's clause 13. And a further question was asked in relation to the position that underwriters would be put in potentially by not being aware of these agreements reached between the commercial counterparties. Now, I'm not saying this is relevant to the hull and machinery policy, but it is instructive to go to page 583 to the kidnap and ransom policy. And at the bottom of the page, there's the warranties section. And the kidnap and ransom underwriters were not interested in the charter party. They wanted a warranty that a copy of it be provided to the underwriters in the event of a claim within 24 hours of the date of the loss. So they knew that they could ask for it if they wanted to study it, but they didn't. They wanted it to be provided within 24 hours of the date of a loss. May I make, again, a very small point in relation to Gilbert Ash? It's an authority which we've been referring to, but we haven't actually gone to at any stage in the hearing, and it's important. There's just one point that I need to make in relation to that, and it's at page 1001 in the bundles, 1001. And the speech to which reference is most usually made in this context is the speech of Lord Diplock, and in particular the passage on page 1029, where Lord Diplock is dealing with the principle of abatement. And in that context, he says that that's a long-standing principle of the common law, and one would expect, the bottom of the page, it's of course open to the parties to contract for a sale of goods or for work and labour, or both, to exclude any express agreement a remedy for its breach, which would otherwise arise by operation of law, or such remedy may be excluded by usage binding upon the parties. But in construing such a contract, one starts with the presumption that neither party intends to abandon any remedies for its breach arising out of operation of the law, and clear express words must be used in order to rebut this presumption. Lord Salmon, who gives the final speech in the matter, he uses slightly different language, and in our submission encapsulates the principle more clearly. 1035 at A, he says, there is nothing to prevent them from extinguishing, curtailing, or enlarging the ordinary rights of set-off, provided they do so expressly or by clear implication. And so it's not just the express words that are important, it's also express implication. The point was made in relation to general average, and putting general average into the category of cases where you'd expect to see red ink and hands pointing to its exclusion, and it was suggested that it is not a tortious or a contractual obligation. That is true in relation to its origins, but it is now almost exclusively contractual in its nature. The rules at play are those agreed contractually between the parties. In this case, the 74 and 94 York Antwerp rules. As my Lord Legate observed, the fundamental question is whether the owner's right to general average contribution is displaced by the insurance code, and in our submission the question admits of only one answer. If there is an insurance code, then it is displaced. If there is no insurance code, then it is not displaced. A question was raised as to whether the Evia principles, which are adumbrated in the context of a time charter apply also to voyage charter parties, this case being a voyage charter, and it's accepted on both sides that there is no case, decided case, where the Evia principles have been applied or considered even in the context of a voyage charter. In our written statement of case, we've given a reference to the leading textbook on this, which considers the question and comes to the conclusion that it does apply equally in the context of voyage.
Do you have the paragraph number?
Yes, if I can get my junior to give that to you just in a moment, I'll be... we were asked, my learned friend was asked a question in relation to international standards on crew bonuses, and it's difficult, neither of us in a sense can give evidence in relation to this, but a very quick look at the International Transport Workers Federation website, for example, does refer to huge numbers of international standards on bonuses in relation to high-risk areas, and so for what it's worth. How does the Gulf of Aden clause work? It seems to us is a crucial matter. Owners take out insurance if they want to take it out. The cap on that insurance protects the charterers and those on whose behalf it's taken out from the owners taking out excessive or atypical insurance. And the third is that on any view, the owners, in agreeing to go to the Gulf of Aden, are not going to leave gaps in their insurance cover. In relation to the Evia, there's just one point that I need to perhaps come back to, the point I did touch on, and that is Lord Roskill's third factor, which was that the off-hire provision was displaced. In the regime in this charter party, what is being displaced by the code is the principles that you may not deviate, the principles that you must proceed with dispatch, the principle that freight is earned at the discharge port. All of those and many others are displaced, and in those circumstances, in our submission, and further, in relation to loss of time, in the charter party, there is a risk allocation in relation to loss of time, which is the equivalent of compensating for hire in a voyage context. Oh, sorry, I'm so grateful to my learned junior. The reference, my Lord Hodge, is page 1601, paragraph 26, stop 78.
1601, paragraph 26. Thank you.
26, stop 78. 2678.
Thank you.
That's true. The court was referred to the decision of the Court of Appeal in the case the Verena, and again I'll just make an observation without taking you back to the case itself. We entirely agree that it's not appropriate to incorporate intentions. However, implicit understandings are objective, they're not intentions. And for that reason alone, the Verena passage relied upon doesn't assist my learned friend. The issues on this appeal have been considered now by 3 tribunals. I would invite and encourage your lordships and your ladyship to return to the award where it all began. The award is powerful and it makes commercial sense. If it contains an error, the error is in paragraph 41. This may be thought to be an overstatement of the law in the light of the Miramar. However, in the event, that does not affect the result at all as found by the tribunal, and so I commend the award to this court as otherwise above criticism. The judge allowed the appeal for 2 reasons. He was unwilling for 2 reasons to manipulate terms which he agreed were incorporated, paragraph 65 of the judgment. First, the bill of lading holder agreed to pay freight and no more. And secondly, the absence of an apportionment formula, the practical problems. And he held that in the absence of manipulation, an obligation on the bill of lading holder to pay the premium, there was no foundation in the bill of lading contract for an agreement by the owners not to seek a contribution for piracy losses from the holders of the bills of lading. The Court of Appeal disowned the judge's first reason, and it has not been pursued. As a result, the decision to overturn the award was based on one reason and one reason only by the judge, and that was that in the absence of manipulation, there was no foundation in the bill of lading contract for an agreement by the owners not to seek a contribution. That was what it was left with. And in our submission, in that regard, the tribunal's forceful reasons as to why that was not a correct conclusion should prevail. The key point was that owners were being relieved of the obligation to pay the premium. It was being paid by the charterers, and it was being paid on behalf of those on the cargo interest side of the commercial arrangement. And it was being made in a context where the only party who was likely to be of benefit from that was going to be the cargo interests. It was not a matter that the charterers were going to benefit from, as is apparent from the general average adjustment, which apportions everything between cargo and ship and nothing to freight. The Court of Appeal's judgment, and that is at page 135, the Court of Appeal's judgment in our submission makes 5 significant errors, and that's why its conclusion is wrong. The first is at page 144, paragraph 41, and the first is in questioning whether the majority in the Supreme Court in the Ocean Victory approved the passages of Lord Justice Longmore in his judgment. And I've shown you, by reference to the Supreme Court judgment of Lord Toulson and to Lords Hodge and Manser's endorsement of that judgment. That's page 127 and 108. And so in our submission, he was wrong to question that. In the end, it made no difference because he assumed, for the purposes of the judgment, that the effectively he assumed that the Evia principles did transpose that the Evia principles were to be found in this charter party in this case. Next, at paragraph 46 he suggested that wide words of incorporation encompass express but not implied terms. And I've explained in detail why in our submission that's wrong. That's a formula, that's a mechanical approach. It's not an approach adopted by modern day construction. It's clearly wrong in principle. There is a passage in the judgment of Lord Justice Ricks in the Spiros C, page 1345 to 1348, where he explains the position clearly, and we effectively would adopt that reasoning, but I won't go into the detail on it. Paragraph 54 is, in our view, the judge's third error. He held that incorporation serves the useful purpose in showing what was agreed between the owner and the bill of lading holder. He says in the last sentence, without the incorporation of these terms, the important issue of the vessel's route under the bill of lading contract would at best be highly uncertain. Question we ask rhetorically, but why is it made more uncertain? As between the owners and the bill of lading holder, the owner can refuse to proceed or go via the Cape if clause 39 is triggered. The route is not fixed. Clause 39 still applies. Owners can still say no. Therefore, despite incorporation, the route remains uncertain and no more or less uncertain. This is not a Helen Miller type situation, the case of the Helen Miller, where the court concluded that the route was effectively bought by the additional premiums. In that case, the owner said, I'm not going there. I will only go to that port if you pay the additional premiums. And the court held that that was a case where they bought that route as a consequence. In our submission, the owner could still discharge at Jeddah if the master formed the view that it was too dangerous to travel through.
Your last couple of minutes now.
I'm on the last, I exactly am, yes. Paragraph 57 is the fourth. Clear words of exclusion are required. In our submission, Lord Justice Longmore, Ocean Victory, paragraph 77, page 997, says that clear words of exclusion are not required if one interprets the agreement between the parties as being an insurance code. Now, I accept that there's circularity in that to a degree, but it's a case of standing back and considering, well, what have the parties to this contract agreed? We accept the Gilbert Ash principle. And then finally 59 to 60 in saying that the cargo owner's insurance is relevant and its liability to contribute in general average was expressly insured under its own insurance. With due respect to him, that is res inter alis acta. It's not something that is relevant, and I've shown you the passage in Carver on bills of lading where that particular fallacy is exposed.
In which case?
Sorry? It's Carver on bills of lading. It's the editors, it's Professors Reynolds and Rose in Carver on bills of lading.
Your time, I'm afraid, is up. Thank you. The court is very grateful to counsel for their assistance in this interesting case, and also to those who have assisted counsel in the preparation of the submissions and the documents. The court will take time to deliberate and produce a judgment in due course. The court will now adjourn.